Hello everyone. Today we'll be talking about fundamental rights. Fundamental rights are contained in Article 12 to 35 of the Constitution of India. Now, Article 12 is talking about the definition of state unless context otherwise provide, which means कि अगर किसी प्रोविजन के लिए स्पेसिफिक स्टेट की डेफिनेशन दी है तो उस प्रोविजन में स्टेट की वो डेफिनेशन अप्लाई होगी, अदरवाइज ये डेफिनेशन फॉर जनरल प्रोविजंस. State include government, that is government of India, and parliament. Second, it includes government of state and legislature of state. Third, it include all the local and other authorities which are there in India. यहाँ पे टर्म जो यूज़ की गई है वो यूज़ की गई है इंक्लूड्स विच रिप्रेजेंट दैट इट इज़ नॉट एन एग्जॉस्टिव प्रोविजन. देयर कैन बी अदर थिंग्स विच कैन बी इंक्लूडेड इन द डेफिनेशन ऑफ स्टेट. Now a question arises whether judiciary will be included in the definition of state. Generally, judiciary is not the part of state, but when judiciary is performing executive functions or administrative functions, for example, जब जुडिशरी जो है वो लोअर कोर्ट्स की जजेस को चूज़ कर रही है या अपॉइंट कर रही है, उस समय जुडिशरी विल बी कंसिडर्ड एज पार्ट ऑफ स्टेट. Now, what is included in other authorities? There is a word which has been used, that is other authorities. अब other authorities जो है उसमें उसको एक ओपन कैटेगरी की तरह रखा गया है, उसको डिफाइन नहीं किया गया. द रीज़न बिहाइंड दैट इज़ दैट गवर्नमेंट कैन क्रिएट as many instrument for the welfare functions. For example, PSU जो government create करती है for their help, that they are also part of the other authorities. So there was a case on this, Z Telefilms Limited versus Union of India, in which a question arises that whether BCCI is part of the state or not. So the court held that state does not have a financial or administrative control over BCCI, so it is not a state. उसके बाद आता है आर्टिकल 13. Article 13 basically says law inconsistent with or in derogation of fundamental rights, कि कोई भी law जो fundamental right के साथ inconsistent है या उसके provisions के against जाता है वो void होगा और unconstitutional होगा. आर्टिकल 13(1) जो है वो प्री कॉन्स्टिट्यूशनल लॉज की बात करता है, वेयर एज आर्टिकल 13(2) टॉक्स अबाउट पोस्ट कॉन्स्टिट्यूशनल लॉज. Article 13(1) says if any provision or any law which is inconsistent with part 3 का मतलब है fundamental rights, तो वो unconstitutional हो जाएगा up to that extent, उस extent तक. इसमें एक doctrine आता है, doctrine of eclipse, according to which the provision will not be removed from the law, it will be there, but उस पर एक eclipse लग जाएगा, एक ग्रहण लग जाएगा, that law will become redundant, वो उसको हम यूज़ नहीं करेंगे, but that law will still remain in the code, or in the existence. इसमें एक एग्जाम्पल है सेक्शन 303 ऑफ IPC, जो कि वी डोंट फॉलो दैट लॉ नाउ, बट इट्स स्टिल देयर इन द लॉ बुक. सो द रीज़न बिहाइंड दैट इज़ दैट इट्स बिन सेड दैट in case in future somewhere we need that law again, so we can revive that. Now we'll be talking about Article 13(2) of the Constitution, which is talking about post constitutional laws. कोई भी लॉ जो कि कॉन्स्टिट्यूशन के एग्जिस्टेंस के आने के बाद बनाया गया है बाय द गवर्नमेंट, बट दैट लॉ इज़ इनकन्सिस्टेंट विद द प्रोविजन ऑफ Constitution Part 3, then that law will become void up to the extent of contravention. Now in this case they are talking about the doctrine of severability. अगर कोई भी लॉ है जिसके कॉन्स्टिट्यूशनल पार्ट को अनकॉन्स्टिट्यूशनल पार्ट से सिवेयर किया जा सकता है, अलग किया जा सकता है, तो ओनली दैट पार्ट विल बी declared unconstitutional, which is inconsistent with the fundamental rights, and the remaining part will remain in existence. For example, there is a section 377 IPC after the judgment of Navteej Singh Johar versus Union of India. Sexual intercourse between two adults, that is homosexual relationship, has been made constitutional, whereas the remaining part is still unconstitutional, that is the bestiality or unnatural sex with animals and all those things are still unconstitutional and unnatural offense but homosexuality is completely constitutional and is not unnatural unless and until it's been done with the consensus. It should not be with force. So that is the doctrine of severability. So any provision which has become unconstitutional after because of fundamental rights, that is because of Article 13, will become unconstitutional prospectively, that is after 1950. Why? Because fundamental rights were not in existence before 1950, and how can somebody which was not in existence can make something unconstitutional, right? So it is prospective in nature. Now Article 13.3, which is talking about what is included in law. Now law includes ordinance, orders, bylaws, rules, regulation, notification, custom, usage, usage or custom which are having force of law. So these are the things which will be included in law. Now you'll see here that they have not used the word amendments. Amendments are also law which are being done under 368, but they are not included here. 13.3b is talking about law in force. Now they are talking about law in force before the constitution. They are saying law passed by legislature or any other competent authority in India before commencement of constitution, that they should be passed by legislature or any competent authority, and the other condition is that that should not be repealed. That will be called as law in force. Now 13.4 is talking about nothing in this article applies to any amendment of this constitution under 368. That is, that if government is doing any amendment under 368, then Article 13 will not be applicable on that. Now what does that mean? That if there is some sort of amendment, then can that go against the fundamental rights? For that you have to read Keshavananda Bharati judgment, which we will discuss in some other video. For now, this is all.